Hi, I'm Alicia Mundy, and we have a story today about preemption. It may be the ultimate Bush legacy for the business community. Preemption is a policy that will basically stop consumers and states from suing corporations over defective or dangerous products, product liability. Preemption is something that the Chamber of Commerce, the business community, the National Association of Manufacturers, pharmaceutical makers have wanted for years. They have wanted some kind of tort reform. And when George Bush campaigned for president the first and second times, he promised that he would eventually find a way to get tort reform and to shut down lawsuits once he got into office. Our story is about how they came up with a brilliant plan at the Bush White House to find a way to shut down these lawsuits. They avoided going to Congress and trying to get bills passed because they would have to face the trial lawyers' lobby, which would likely block business. The business and White House community also didn't want to have to go to the courts because the courts are largely a crapshoot. They came up with a very clever strategy to add language preempting lawsuits to obscure federal regulations that are across agencies. They affect the safety of products ranging from prescription drugs to mattresses, motorcycle brakes, your car doors and your car door locks, the strength of your car roofs, whether your railroad cars have to be strong enough to withstand a collision and not drop hazardous spills into the environment. We found 50 some of these regulations just in the last 4 years across 5 or 6 different agencies. What's interesting in our story is that the gentleman who was instrumental in helping create this policy and helping come up with an idea on how to end lawsuits talked with us about why this was important to the Bush administration. He said this is something they should be very proud of because corporations were faced with hundreds of millions of dollars in liability lawsuits in the last 10 years. They were just spiraling. And in addition to that, many of the lawsuits were based on differing federal and state standards for safety. Preemption basically says there is one standard for safety for all of these products and issues, and the federal government should determine what that is, and a state shouldn't be able to pass a law that is tougher or different. That's where people have found they had a right to sue, by hanging to the state law that said a drug company should have put a harder warning on their label, or a car manufacturer should have guaranteed that their door lock wouldn't fling open in an accident. Another interesting issue in our story is that states will be prevented from suing. People don't realize this, but many states sue drug manufacturers over Medicaid costs. Some states have paid millions of dollars for drugs that later turned out to be defective or dangerous. They want to recoup those costs. They want to recoup those costs from the manufacturers, or they want to be able at least to hit the manufacturers with the cost of paying for patients who are later injured or killed, because that ultimately comes back on the state health services. Under preemption, states stop suing, and that's already had an impact. The state of Alaska had sued the makers of an antipsychotic drug called Zyprexa for millions of dollars. They've basically settled for $15 million, which is chump change compared to what the suit was for, because they are very worried that preemption will come to pass this year or next, and they will have no grounds to recover any money at all.